filing of these limited documents under seal. So in that motion asking for leave to seal the motion, Attorney Roberts makes it clear that
the motion was filed under seal. The reason given: these documents contain highly sensitive mental health information, the public disclosure of which would unnecessarily invade the defendant's privacy. But here's what that legal language actually means. Think of a man who is asking the court to look inside his head, but asking that no one else be allowed to see what they find. Picture a psychiatric evaluation that the public is legally barred from reading, while the very charges it's meant to address involve the public's most basic responsibility, protecting children.
So Gary Jr., at least during his initial appearance, asked to speak with a lawyer before entering a plea, and Judge Rogers entered a not guilty plea on his behalf.
Before we go deeper into what the documents actually show, make sure you're subscribed to True Crime Court, because we don't just cover the story, we follow the evidence. Gary Cers Jr. is 36 years old. He's the father of 16 children removed from an Ohio home. And at his first court appearance, he did something that told the judge he understood the situation well enough to demand his rights. He asked to speak to a lawyer before entering a plea. That's a constitutional right. It's also a sign of competence.
He has a lawyer, and that lawyer is planning to ask the court for a mental health evaluation to determine whether Gary Jr. is fit to stand trial. Attorney Arley Roberts has filed a motion asking Judge Rogers to allow him to file a motion.
Now his attorney, Arley Roberts, has filed a motion asking the court for permission to file a separate motion, a competency evaluation, entirely under seal. That means the public will never read it. The legal argument is privacy. The practical effect is this: the man who supposedly couldn't understand the proceedings against him knew enough to ask for a lawyer. And now his lawyer is arguing that he might not know enough to stand trial.
The documents at issue concern defendant's present mental health condition and requests for psychiatric examination. These documents contain highly sensitive mental health information or information directly reflecting defendant's psychiatric condition.
The motion itself reads like a paradox. It states that the competency evaluation concerns defendant's present mental health condition. It acknowledges that the documents contain highly sensitive mental health information, and then it requests that this information be kept from the public because revealing it would compromise the confidentiality of competency-related proceedings. The paperwork already
Defendant does not seek to seal the entire case record, but only the competency motion, proposed entry that disclose or concern defendant's mental health condition, and competency evaluation. No less restrictive alternative would adequately protect the confidentiality interests at.
But the family didn't just appear out of nowhere. They lived in a house in southeast Ohio where conditions were described as disgusting. 16 children, ranging in age from 18 months to 18 years. And with one exception, a truancy complaint filed back in 2021, they were entirely off the radar. No school records, no social services, no one asking where they were. The question isn't whether Gary Cers Jr. can understand a courtroom. The question is how a family of 18 people evaded every system designed to find them.
So it's really about your present state at the time, and if you're able to understand the proceedings in the court.
Competency isn't about whether you did something wrong. It's about whether you can understand what's happening to you right now. As forensic psychiatrist Dr. Daniel Bober explained, it's really about your present state at the time and if you're able to understand the proceedings in the court. That's the legal standard. It's narrow, it's clinical, and it has nothing to do with guilt.
No, it doesn't. In the state of Ohio, people are presumed to be competent, and competency can be raised by either the prosecution, the defense, or the judge themselves. So in this particular case, what we're looking at is the defendant's present state of mind. Distinguish that from their state of mind during the commission of the crime, which would be a sanity evaluation. And so
in Ohio, every defendant is presumed competent, but competency can be raised by the defense, the prosecution, or even the judge. The test is two-pronged. Can the defendant understand the nature of the proceedings? And can they assist in their own defense? If the answer to either is no, they're incompetent. But here's the distinction that matters. This is about now, not then. The paperwork already knew.
All true. And it's important to note that even if you are suffering from a psychiatric illness, for example, schizophrenia or bipolar disorder, that doesn't per se mean that you will be found incompetent. So it's really about your present state at the time. And if you're able to.
Dr. Bober made it clear having a mental illness doesn't automatically make you incompetent. Schizophrenia, bipolar disorder, none of that is an automatic pass. It's about whether the person can work with their attorney, understand the roles of the prosecutor and the judge, and participate in their own defense. That's a low bar. And Gary Cers Jr. already cleared it once when he asked for a lawyer.
So that right there shows me that he understood enough to actually ask for a lawyer. He wanted to consult with an attorney. What does that tell you about his potential competence here?
So why is his attorney pushing for this evaluation now? The answer might be strategic. If a defendant is found incompetent but restorable, they can be committed to a psychiatric hospital for up to a year, and the case freezes. But if they're found incompetent and not restorable, the case might never go to trial at all. That's not an insanity defense. That's a timeout. And in a case with 16 counts of child endangering, a timeout might be exactly what the defense needs.
But potentially restorable, he would be committed to a psychiatric hospital or some outpatient facility where they could try to restore his competency and potentially receive involuntary medication. And generally, with serious felonies in the state of Ohio, that could be up to a year.
Dr. Bober outlined the possibilities. If Gary Jr. is found incompetent but potentially restorable, he could be committed to a psychiatric facility. If he's found incompetent and not restorable, he could still be committed, but only if the court believes, by clear and convincing evidence, that he committed the crime and remains a danger. That's the loophole. A man who cannot stand trial can still be locked up, but he won't be convicted, and the public may never know why.
How long does that take, that evaluation? Is that something that can be done, in an afternoon? Does it take a couple of meetings with a defendant?
The evaluation itself is straightforward. A clinical interview, a few hours, maybe 2 or 3 visits. There are instruments designed to test whether someone is faking incompetence, a practice called malingering, and it happens more often than you might think. Because if you're facing 16 felony counts, pretending you don't understand the courtroom might seem like a viable strategy.
Do defendants ever feign incompetency during an evaluation or fake it or try to exacerbate symptoms?
Yes, and very often psychologists will use instruments to detect that malingering or feigning that you're describing, which is not uncommon.
Do defendants ever feign incompetency? The answer is yes, and psychologists are trained to spot it. They use specific tests to detect exaggeration or outright fabrication. It's not uncommon, and for obvious reasons. Why would anyone want to be found competent when the alternative could delay or derail the entire case against them?
Well, it's true. And there's a lot of layers to this, right? So if you're someone who's in the public who's looking at this case, you're looking at the way this guy treated these kids and you're thinking, this guy has to be mentally ill if he would treat these kids this way and he would do it for so long. But again, that doesn't necessarily mean he's incompetent. That is a totally separate skill set from, again, being found not.
Criminal defense attorney Janice Spilbor put it this way. This is like no other case I think we've analyzed in my career. And she raised the central contradiction. This family knew how to evade detection. They knew how to hide. They kept 16 children out of school, out of the medical system, out of sight for years. That takes planning. That takes awareness. That takes competence. So if Gary Cers Jr. is competent enough to evade the state, how is he too incompetent to face it?
Competency determination is not the same as insanity. And a lot of people will confuse the two. So competency, why it makes sense here is because it's to gauge whether or not at the current time, so it doesn't look back really to the history, at the current time, does the defendant understand the proceedings and can he assist in his own defense? So
competency is not the same as insanity. That distinction is critical. Competency looks at the present. Insanity looks at the past. You can be legally insane at the time of the crime and perfectly competent now. Or you can be competent at the time of the crime and incompetent now. The defense is asking the court to look at Gary Jr.'s current state of mind. Not what he did, not what he knew, not how he lived. just whether he can sit in a courtroom and understand what's happening.
That indicates this defendant had deficient mental capacities. And now here we are facing several felony charges. And does he get it? Does he know where he is? Does he know what a court proceeding is? Does he?
But the question that lingers isn't legal. It's human. This family lived in filth for years. Many of the children couldn't speak. They couldn't write their names. They were never socialized. And now the father of those children is asking the court to decide whether he's too mentally unwell to be held accountable. The paperwork already knew.
Well, he must be competent because this family knew how to evade detection. They knew how to hide. They weren't in school. How were they living? Nobody applied for social services. Do you do that?
Spilbor said it bluntly. This family knew how to evade detection. They knew how to hide. That's not the behavior of someone who can't understand the world around them. That's the behavior of someone who understands it all too well. A family that avoids schools, avoids doctors, avoids social services. That's not incompetence. That's evasion.
His father, Gary Sr., they've raised that issue with his father because he seemed really out of it at his initial court appearance. So I'm wondering, are we going to see this raised in the other cases? Because, Jonna, we're really at the complaint phase of this case where they've waived their preliminary hearings. We haven't even seen it in.
The court has already ordered a competency exam for Gary Sr., the 73-year-old grandfather who appeared confused at his first hearing. But Gary Jr. is different. He's 36. He appeared to follow directions from corrections officers. He asked for a lawyer. He answered the judge's questions. If he's found incompetent, it won't be because he looked confused. It will be because his attorney argued that something inside his head makes him unable to face what he's accused of.
Answers. I mean, the only update we have on the children is that they're in therapeutic foster care. We don't even know their exact conditions, and maybe we shouldn't know that as the public because it's health information. It's protected by HIPAA, but it would be nice to receive.
And what about the children? They're in therapeutic foster care. That's all we know. We don't know their conditions. We don't know if they're recovering. We don't know if they'll ever speak or write or live like the rest of us. That information is protected, and rightly so. But the gap between what we're allowed to know and what we need to know is part of the tragedy.
Well,
it's going to be such a long road for these kids, and probably even worse for the older ones. I think the oldest is 18 years old. And if that child lived, since we have no records, like so if that child lived his or her entire life without reading, writing, arithmetic, without proper nourishment, with bacteria, with feces, with disgust, with not being socialized, that's hard.
The oldest child is 18. If that child lived their entire life without education, without proper nutrition, without socialization, the damage may be permanent. The younger children have a fighting chance. But the question that hangs over this entire case is simple. How did this happen for so long to so many children without anyone noticing? And the answer might be sealed, along with the competency motion, somewhere in a file we'll never see.
Now to Jonna Spilbor. She's a criminal defense attorney and also the host of Positively Legal on the MK True Crime Network. Thank you so much, Jonna, for coming.
If you want to follow this story, start with the motion itself, the public filing that asks the court to seal the rest. It's docket number 22, CR Alzen 45 in the Vinton County Court of Common Pleas. Read it. Then ask yourself, was this motion filed to protect Gary Cers Jr.'s rights, or to protect something else entirely? Drop your answer in the comments. And if you believe the public deserves to see the evidence behind the seal, like this video, share it, and make sure you're subscribed to True Crime Court with notifications on. Because this story isn't over. It's only just beginning.